Hello everybody. How are you? I am being told by my system here that I am live, I think, almost. Hi, I'll say hi again, just in case I'm just coming through now. I will give you a little insight into what has been going on here at YSP Friday Happy Hour headquarters. We had a tech glitch, as sometimes happens, and I'll just get the mic on the other side there muted. If I can ask my trusty assistants in the background there, just getting some audio from another mic. So if I can get that one off, that would be great. But we're here, tech issues and all. We are on a different platform to the usual. So things might be looking a little bit different. But we're here and you're in the right place for Friday Happy Hour. I have a very exciting, very special guest for you today, Helen Cowell, as I have described her, our strata building defects guru. She is the woman with the information that we need to be across what's happening with all this reform that's going on in New South Wales when it comes to building defects and how we are better protecting our owners living in relatively new strata schemes. So that is super exciting. If you are here coming in for happy hour today, feel free to give me a hello in the comments. It is going to be interesting because working on my different platform today, I am having to flick screens to have a look at your comments. So I will do my best, but if you are there ready to go for happy hour and want to pop me a hello, please do, so that I can work out how I can see these. I was just chatting to Helen before we went live, and she was having some trouble with her camera. We've switched over to Zoom, and she said, I have been using Zoom 3 times a day, every day for the last 3 months. And of course, the day that we need to go live on time, it doesn't work. But that is all part of our learnings here as we get used to this whole new world. So I am just going to flick a few screens here to make sure that I can see you all as you're coming in, but it is good to be here. I'm going to give you some updates, some interesting things that have been going on, particularly in New South Wales when it comes to strata the last couple of weeks. And I am also going to let you know about a couple of things that are happening that you may be interested in, some important surveys being done, an event that's coming up. So I will give you those summaries, and then I'm going to pop back to the comments over on the page that I am flicking across to make sure that I can see you and that you're here. Now I am seeing Bruce. Bruce is saying greetings. Thank you, Bruce. And that encourages me and reassures me that I do have a way here on this platform to see your comments. So that is awesome. You will have some questions, no doubt, as we go along, especially as I bring in our special guest today. So please do pop your questions in that comment section. I can see them, which is awesome. Now, some of you regular visitors to the page, those of you who follow what is going on here in Strataland in New South Wales, will have perhaps seen a post. It was quite a popular one that I put up on the page towards the end of last week, and it was alerting you to the fact that the New South Wales law, when it comes to abandoned goods and motor vehicles on the common property, the New South Wales law has changed. And I said, well, I was really taken by surprise here. There's a section of our Strata Schemes Management Act in New South Wales that doesn't exist anymore. It has been repealed along with the associated regulations. It is section 125. I'm going to say straight up, big thanks to Tim Sara at Strata Choice for pointing this out to me. There was a discussion going on inside our members only forum, our Q&A forum that is open to members of our online community. And it was about how best to deal with those who are parking illegally on the common property. And Tim, helping one of our members, had gone over to have a look at section 125 and it wasn't there. He couldn't find it. So he let us know about this repeal. It was repealed on the 1st of July, and it was repealed as part of some fair trading miscellaneous amendments that were actually drafted a couple of years ago, but took effect, this particular part that repealed section 125 took effect on the 1st of July. Now, this was the section that allowed us to place notices on abandoned goods as well as vehicles that were obstructing the common property or blocking an entrance or exit, to place notices on there, leave them for at least 5 days, and if nothing happened to the goods or the car, then you could move the goods or the car, and you were taken to be, the owner's corporation was taken to be the owner of the vehicle and the owner of the goods for that purpose. Now, I know that a lot of buildings, when this came out in our 2015 Act, got really excited about this and started incorporating these provisions into their bylaws to make it a bit clearer for owners. Hey, we have these rights to deal with abandoned goods and vehicles that are not parked where they should be. So better make sure you're parking and putting everything in the right place. Otherwise, you're going to get one of these notices. Well, this law doesn't exist anymore. So if you have bylaws that refer to section 125 of the Strata Schemes Management Act or regulations, those are gone. Everything is now dealt with by the Uncollected Goods Act of 1995. This is an interesting piece of New South Wales legislation. Apparently, this is an attempt to simplify the law and have all legal provisions relating to uncollected goods in the same piece of legislation. So the Uncollected Goods Act has been amended to refer to the Strata Schemes Management Act. But it is not, in my view, as effective as our section 125 was or had the potential to be, because it requires the goods to be abandoned. And I think we're going to have some difficulty there if you go and have a look, dig into the Uncollected Goods Act at proving whether or not goods have been abandoned. And we can't deal with motor vehicles unless we have an order from the Commissioner of Police. So a little bit disappointing there that this seems to have taken us in the strata sector by surprise. I know a couple of lawyers who were commenting on the post as well said that it was new to them. There is a link which Rochelle is going to put in the comment section here for you. It's a fair trading page which explains a little bit more about uncollected goods and how all of that works. But it's something I'll be looking a little bit more closely at. And as I said, if you've got bylaws that deal with goods and vehicles and you're referring to section 125 of the Act, then those are going to need some revision. So thank you again to Tim Sarah for pointing that out to us over in the members area. If anyone is interested in finding out more about this members area where I say we have all these clever cookies giving us information and getting one-on-one guidance from me and my team, you want to head over to yourstrataproperty.com.au/membership. Excellent. Now I'm flicking back over to my screen here and seeing lots and lots more of you come on through. You are more than welcome. This is Friday Happy Hour, and I will very soon be welcoming in our special guest expert. If you are here and want to say hello, let me know what you're up to this afternoon, how you're enjoying your happy hour. If you're having a little drink of something, what you got there, feel free to post in the comments. Give me a hello. Let me know how you're doing. I will pop back over there and have a little look. But for now, I want to tell you about this, about a webinar that is coming up. I am running one of my famous, I'll call them, bylaws webinars, this time for Cumberland Council. This one is going to be happening on Thursday, the 6th of August. In these webinars, I share how you can use bylaws to combat bad behaviour in your building. I've been running these webinars for some time now, and I know many of you will have been on one of my bylaw webinars before, but it's always a good idea to tune in and get the update. There's always something new that I'm adding in there. Our law is changing. We've got new cases, especially when it comes to pets. Those are the real updates that are happening in New South Wales, learning more and more about what is harsh, unconscionable or oppressive when it comes to bylaws. So the webinar will definitely be up to date on all of that. Thursday, the 6th of August at midday, and Rochelle is going to put the direct registration link in the comments there for you if you want to join me on that webinar. With thanks to Cumberland Council for that one. Now, if your inbox is like mine, you may have heard from a couple of different sources this afternoon that there is a new survey going around, a survey on sustainability infrastructure in apartments. So we as owners, as committee members, as tenants even in apartment buildings are being asked to participate in an online survey to share our opinions, our motivations, our experience with sustainability infrastructure. So we're talking about solar panels, batteries, digital meters, hot water systems, electric vehicle charging stations, and other emerging innovations, as we call them. The survey is part of a research project by the Institute for Sustainable Futures at the University of Technology in Sydney, as well as Green Strata, and it is being run on behalf of the Department of Planning, Industry and Environment. So they want to understand the challenges that owners are facing when it comes to installing this infrastructure in apartment buildings. So 10-minute survey, please do fill it out. Not too much time. It needs to be done by the 9th of August. And I hear that if you complete this survey, you go into a draw to win an iPad. Cool, can always do with more devices. Sounds good to me. Complete the survey by the 9th of August. We are putting a special link that is our own Your Strata property link to the survey in the comments. So go ahead and check that one out. I am very soon going to bring our special guest expert onto the show. I am seeing some comments come through, so I'm just going to head back over and say hello. I am, as I said earlier, you may have missed the start. I'm on a different platform today. We did have some technical issues in the beginning, so I'm a bit concerned that I may not be able to see everybody's comments, but I'm going to do my best, do my absolute best here. I will come back to those very, very shortly. Excellent. Okay. So you're here, you're ready to go, guys. Here we are. I am going to welcome in our special guest expert, Helen Cowell. Now, Helen prides herself on thinking outside the square, finding creative solutions to difficult problems. She has a legal career spanning over 25 years in general practice. She specializes in building, construction, strata, and property generally. Many of you have worked with Helen during her career in strata. We are really thrilled to have her joining us today, sharing her expertise about building defects and building construction litigation in particular. I think she's already here on your screen. Helen, hey, how are you doing? Welcome.
Hi, I'm good. How are you?
I am doing very well. I am doing my best to cope, as I keep saying, with our new setup here. And I hope we're all...
Yeah. I think we've established I'm not a technician, and given I've been around for a long time, I'm definitely not technical, so apologies.
No, it's not your fault at all. It's often just the tech on some days works for us and some days doesn't. But I am seeing plenty here to hear your particular expertise today. This is a topic that we all need to be across. As I've been saying in my notes, I've been warming everybody up to come and listen to us here today. Now, I'm going to start here, Helen. I have heard a bit of news that you were meeting with our Building Commissioner David Chandler this week. I don't know if that was the first time or you've been in consultations for a while. How did the meeting go? What's the scoop? What were you guys talking about? Give us the update.
Okay, yeah, I caught up with David yesterday. That was my first meeting with him, but it was good to have a catch up, just a general chat about what he's doing, what's happening on the ground with the reform. He was getting some insights on areas that, you know, everyone was concerned about, what we needed to hear, and what's getting out there to the public. So it was a good chat. We went through obviously the reform that's come in, Design and Building Practitioners Act, along with the Residential Apartments Buildings Act that came in on the 11th of June. Those two acts have been passed through Parliament in the last stages together. There was a bit of a halt with the Design and Building Practitioners Act after it was introduced into Parliament last October. Mm-hmm. And in November, it sort of stalled for a while, and I'm informed that that was because until accommodation had been made for the provisions under the Residential Apartment Buildings Act, the Design and Building Practitioners Act probably wasn't going to get very far through Parliament. So since November, the RAB Act was very quickly drafted and passed through Parliament with the Design and Building Practitioners Act. So they've both come through together. Obviously, they've arisen due to the massive, I guess, shake-up in the strata construction industry or the general construction industry over the last few years in New South Wales. We've all seen Opal Towers, Mascot Towers. We've seen the media hype. And the government was already responding to the Sheargold Weir report, which came out in February 2018. They responded in February 2019 and have been one of the more proactive state governments in responding to the construction industry crisis, I guess you could call it. Mm-hmm. So those responses to the reform, there was 24 recommendations made by Peter Sheargold and Bronwyn Weir in their Building Confidence report, and the government's responding to them. I'm told that they're working hard on their 6 pillars of reform. Those 6 pillars were released in February this year, mm-hmm. And David is very confident that they are going to work. So those pillars are based on customer-focused regulatory frameworks. They're implementing rating systems to generate a greater transparency. Now that will be quite interesting. They're focusing on identifying the risky builders.
So this is a rating system for builders?
Yes. Yes, so there's a new platform coming out. Mm-hmm. They've got tenders out there at the moment for companies to manage this platform. Mm-hmm. It will be a digital platform where effectively every builder, every designer will be given a unique code, mm-hmm. And plans for construction will contain that code. Plans as built will contain that code. They're essentially building what they call a DNA for a building. So they're going to have everything in the one place, your certifications for products, your design compliance declarations, which I'll cover off under the Act, all of the plans. And if something doesn't match up down the track, then it will be able to be identified very quickly. So I think that's quite promising. It sounds like they're going to be keeping an eye on people a lot more than they have been.
It does, and yeah.
He's now got the power under this legislation to do things.
Okay. Now this is for new builds in particular you're talking about.
Yes.
So
yes. So so the legislation will come into play. The Residential Apartment Building Act starts on the 1st of September this year.
Okay.
So from that day, developers have a much higher obligation to mm-hmm. keep the Secretary informed of building apartment buildings. Mm-hmm. The Act only relates to residential apartment buildings at this stage, and it's not intended to relate to other buildings at this stage, just residential apartments. So the Commissioner has quite a broad power under that Act to yes. Issue stop work orders and stop OCs being issued, to prevent strata plans being registered.
Yes, I want to get into that. Before we do, a lot of people who will be watching this will be living in or managing existing buildings that may be in their past their first 2 years, maybe within their first 10 years of existence, let's say. What impact does the, I want to say the name right, and I'm going back to my notes here. What impact does the Design and Building Practitioners Act have on existing buildings?
Okay, so on existing buildings, the Act was passed on the 11th of June, and most parts of that Act aren't in force until the 1st of July next year.
Okay.
But one part that is in force immediately is Part 4, which is the duty of care provisions. So that is a really big one for owners corporations and strata managers to be aware of. So that is in force immediately. It's retrospective for construction work done over the past 10 years. And effectively, the duty of care extends to builders, engineers, designers, and even manufacturers and suppliers for products. So if you have a defect and you're out of time under the Home Building Act, so you've passed your 2-year warranty, you've passed your 6-year warranty, you may have rights to bring an action for economic loss under the duty of care provisions. So it is a massive, I guess, path for owners corporations to bring a claim if they've suffered economic loss.
Yeah. And this is a duty that we were told by the High Court in the Brookfield Multiplex case that builders and developers didn't have. So we've now, the New South Wales government has now legislated, it sounds like, to create this pursuant to this legislation. So very interesting, very exciting for those buildings who may be out of their 6 or 7 year warranty, but still within that 10 years.
Yeah.
Are you receiving inquiries from buildings in that bracket saying, look, can I get some advice on whether I've got a claim here?
Yeah, we've had a few schemes. Obviously, the primary path would still be the Home Building Act. It's breach of statutory warranties. If you're within time, I wouldn't be recommending running off to commence under the Design and Building Practitioners Act. But for the bigger claims and for some where there's some time limitation questions, you would definitely be pleading that in the alternative, and you would be joining any concurrent wrongdoers, so subcontractors, etc., under those proceedings.
And this 10-year duty, is this 10 years from the date you suffered the loss?
No, so that's what the Act is a little unclear on.
That's why I was asking you to clarify. I've got to have all the answers here for me, Helen.
I know. So it does, so under the provisions, if you have any loss arising from building work done over the past 10 years, but it is subject to the Limitations Act and to the Environmental Planning and Assessment Act, section 6.2, so the old 109 ZK. So although there's only a notation in the legislation about the applicability of those two pieces of legislation, effectively the opinion is that your right is for 6 years from the date you become aware of your loss.
Right.
So if you have construction work in the past 10 years, but you came aware of your loss 4 years ago, then you still have a couple of years to bring a claim. And yeah, so it's a little vague, but that's what the intention appears to be.
Okay, and we'll let the lawyers argue that one out.
Yeah, I'm sure there'll be lots of arguments.
Yeah. Okay, well, sounding like a good thing to me. The residential apartment buildings legislation due to start, you said the 1st of September, that you were giving a little bit of an overview earlier about these powers that the Commissioner is going to have to investigate, powers to prevent the registration of a strata plan. This all sounds good. Can you tell us a bit more about that?
Yeah, so this is one power that the Commissioner informed me yesterday he's going to be hitting the ground running with. He's going to have a team, boots on the ground, as he puts it, ready to enforce the legislation. So he has quite broad powers under that Act. Developers have an obligation to give prior notification to the Secretary before 6 months, I think it's 6 months before applying for or intending to apply for an occupation certificate. If they fail to give that notification, then the occupation certificate may not be granted. If there's serious defective work found in the building, or they haven't paid the bond there's various grounds that the Commissioner may, or the Secretary may, impose an order preventing the issuing of an occupation certificate and a registration of a strata plan.
Okay. Now, I had read somewhere, I can't remember where it was now, that there was something like 1,000, maybe more, new strata schemes being registered. I don't know if it was each month. That sounds like a lot. You might know these figures, in New South Wales. And there was some concern about backlog with our building commissioner's team. And you've just said you've chatted with him within the last couple of days. He's got this team ready to go. Do you think they're equipped and ready to keep the sector moving, if you like, if they've got to go and inspect everything properly?
Yeah, I think that their focus is definitely going to be on the risky category of builders. They've already identified, I think, probably a number of sites where they're going to be looking very closely at. Their primary focus is to establish a trusted network of builders, and that will come into play for the insurance proposed, etc. So there will be insurance offered to trusted builders, but may not be offered to the risky builders. So they're sort of talking that bottom 20% of builders will be focused on. The Commissioner assures us that he's going to be ready to go. So it obviously sometimes paperwork and procedure gets in the way, but we'll see.
Yeah. Well, a fair bit's been achieved in a relatively, let's say, short space of time. I know some people were calling for faster action. Some people were calling for further studies and investigation. But it sounds like we're on the right path to me. But you're the expert. What do you think? Are we doing all the right things here? Is this going to be part of the solution, or are we?
Yeah. Look, I think it's definitely a step in the right direction. There was a few questions skirted around yesterday. I've been working closely with a number of experts over the last 12 months, getting their feedback about what their views are on the whole operation of the construction industry. There is a lot of concern that all of these practitioners are going to be asked to comply with the BCA when there's obviously problems with the BCA.
Right.
There is still a big disconnect between showing or teaching builders how to build a good building. There is a lot of updates required to standards, performance solutions. The whole system just isn't quite working as far as the experts are concerned. They're not seeing enough changes in the standards being made to reflect what needs to be done to address the defects. So it's not correlating between what they're seeing in the courts, the issues in the courts. The standards are not being updated quickly enough. And it's a very complex procedure to update the standards. So I'm aware that there's a waterproof advisory committee, and the Commissioner did say that they were hoping to introduce some changes to the waterproofing standards. Obviously, there's a big problem with waterproofing, as has been identified in the recent studies. And the experts are saying that there's no instruction on how to tell a builder how to build properly. So everyone's expecting them to comply with this BCA, but the BCA itself may be deficient. Commissioner assures me that they're expanding training, education, they're expanding teams to update the standards, but I think that will be the slowest part of the whole reform. I think it'll take some time. I've been told that if standards are changed, it will take 3 to 6 years before any impact on that is seen. So I think that that's something that probably could be focused on a little more than it has been. They will come out guns blazing and obviously address the builders and developers and certifiers that aren't doing the right thing, which is good, and trying to create that trusted network. But I think that there's still a shortfall with the inherent problems with the BCA that need to be more adequately addressed.
Yeah, and it sounds like that process should be started sooner rather than later, because we see the fallout from that some years down the track.
Yeah. And I think another thing is the insurance. There's big questions about, will insurance be available for all these practitioners that are required to be adequately insured? I'm assured that there will be, but you know, that's a big problem and has been for some time.
Yeah. Now, if I can just beg an indulgence of you, Helen, and our viewers at the moment. I know there are many of you there. I just need to switch over to my other screen and try and open up these comments. I can see that they're there. If you have a question, let's start off with questions relevant to building defects. And while we've got our expert here with us, I do also want to acknowledge, though, that you've got two New South Wales strata lawyers here too. And if you do have a general strata law question, feel free to pop it in the comments there, and Helen and I will put our heads together and see if we can help you. But the indulgence I'm begging is that I am just having to open up my screen, and what happens is that I end up blasting my ears because I get two different streams at the same time. But here we go. I'm going to press this button here and then turn off. Good. Okay, I've sorted it. I can now see all of your excellent comments. I can see you guys that you are here, which is amazing. I want to say hello. Bruce, I know I said hello to you earlier. I want to say hello to Robert. How are you? And Robert is asking a question here. What are the current regulations for a building completed April 2019? The developer is very slow to rectify issues. Do you want to jump on that one, Helen?
Yeah, sure. So completed April 19.
That's it. Yep.
Yeah. So you're still within the Home Building Act statutory warranty 2-year period. So that would be your primary cause of action. Keep a close eye on that 2-year warranty period. Get your reports in order and get that claim in before the 2-year mark.
Yeah.
Yeah.
And definitely what I say, Robert, when I'm asked that question on platforms like this or from members inside my community, is that you really should be getting some legal advice, at least in that preliminary stage, to understand what the relevant timeframes are and what documents you may need to be getting together. It's important not to miss those timeframes when you are operating under the Home Building Act. And I will now say this, which I should have said at the top of this episode. Don't contact me for building defects advice. I don't do it. I don't do it anymore. My team is not set up for it. That is why Helen is here. And I will, Helen, ask you to let our listeners know, our viewers know, how they can best contact you. She is your go-to gal. So anything I say about contacting lawyers is with no self-interest whatsoever. Now, I'm just going to keep scrolling through here because I can see more of you here and maybe some more questions. Joe, hello. Good to see you. Thanks for letting me know we're on. Good. There is Joe is answering a question there for Robert, which is good, about a specific problem. Hi, Gary. No problems being late. Good to see you here. Bernadette is here. Elizabeth is here. Elizabeth saying the Commissioner's 6 pillars are based on Shergold Weir's 24 recommendations. Yes, that every part of the construction process is registered. It's still self-regulatory, not unlike the issue with certifiers at the moment. So what's the difference? It sounds like another layer to me.
Yeah, I think it will remain to be seen what comes out of these pillars. Apparently this digital framework is going to be like I think he called it a bad smell. It's going to stick with builders and developers their whole career. So everything they do will be on the same digital portal. And if they build a terrible building in year 1 and come back 10 years later to build another one, then people will know that they've built a bad building. But you know, I think it's like anything. It's I think there's going to be a lot of work to get it up and running, and it will take time for the results to actually make a difference or come in.
Yeah, definitely. I can see Joe in there answering questions about pressure washing and all sorts of things. So thanks for being our technical guy on the ground there, Joe. I am just carefully reading out the questions because I'm conscious of the fact that Helen can't see them because we're on our different platforms. So if you do post something in there that's long, please forgive me while I read that out and make sure that Helen is across it. Helen, I want to make sure that those who are watching this, who are managers or who are in these buildings that may have one of these claims under the new legislation when it comes to this new duty of care that's been established, what should they be doing? Let's say that they don't have lawyers involved at the moment. They're in a building that may be outside of their 6-year period. They're wondering about whether this new legislation can help them to recover some losses from a builder developer. Time is of the essence, I can see. What would your advice be to them, or your guidance? We don't give advice on this page. Your guidance be to them about what their very next step should be.
Yeah, so if a manager's aware that they're out of time for the 6-year warranties, but they're still within sort of 10 years, or even if they're not sure whether they're in 10 years, they should get some advice about the time limitation periods for the new provisions, at least. And obviously, if an owner's corporation is undertaking extensive rectification works because of defects that haven't been claimed, then these provisions apply in addition to any other Home Building Act or any other claim that may have been lodged. So it just broadens the statutory duty of care obligations, and definitely worth looking into if a scheme is undertaking massive remedial works and they haven't been able to claim it before for whatever reason, then they should be getting some advice about how the provisions apply to them.
Yeah, and I'd be interested to hear from any strata managers who are watching whether you are establishing any procedures within your offices about how you communicate with buildings who might sit in that category. The last thing you want to hear, I imagine, from a client is, we wish we would have known that we had this new opportunity to make this claim. Perhaps previously they've been advised that they're out of time under the Home Building Act, their warranty is up. And I'm just interested from the strata manager perspective, are you within your teams? There's a lot of senior managers I know who tune in and often tell me what's going on the ground. Are you having meetings where you're putting in place policies to perhaps have a standard form of communication to buildings of a certain age to say, look, it may be worth looking at this and getting some advice? Of course, not being qualified strata managers to give that advice, but indeed, I think being aware that this new legislation is in existence and having a chat to your committees in particular about whether they want to get some more information about it. Would you agree that that should be something that's happening in the background there with strata managers, Helen?
Yes, definitely. It's it has opened up. Look, we've got a long way to go in seeing. I'm sure there'll be lots of arguments about how the provisions are going to work, as usual with legislation. But definitely should be taking some proactive steps, and particularly for those schemes that are suffering huge losses because of having to perform rectification works. And opening it up against manufacturers, suppliers, subcontractors, that certainly, widens the pool of money that they could get.
Yes, and puts plenty more work on your desk, I'm sure, Helen. I have to say, I don't envy you. That's the reason I don't do this litigation. Yeah, full on. I can see your questions coming in. I can see your question there, Pamela. We will come to that. I do just want to let everybody know, if you've got a general strata question, we are here at your disposal. I'm going to regret saying that, I'm sure. Feel free. We are New South Wales practitioners. If you want to pop in a question that's been bothering you, that you want the answer to, go on ahead and Helen and I will have a little look at those. I'll be back there in a sec. Helen, what's next? You're doing a lot of education. I know you're doing seminars for lawyers. As we said, you're communicating with the building commissioner. What's on your agenda in terms of getting the word out more about this legislation, talking to government? What's up for you in the next, say, couple of months?
Just trying to talk to people, find out more about what's going on, getting the information out there. One of the things that the Commissioner realised yesterday was that perhaps the information's not getting out as much as it should be about what's actually happening. I have a lot of reservations about the whole plan, just based on the deeply inherent problems that are experienced in the BCA itself. So I think there's still a lot of work to be done. So I'm just doing a series of seminars with a few people, spreading the word about what's happening and perhaps what we can do to make it happen faster.
Yep. Excellent. Well, if there's anything happening that might be available for owners and managers, some education that you're doing, do let us know and I'll help to share the word about that. That does remind me that you have shared with me, Helen, a paper that you've written specifically about this new legislation, and we have managed to just put that on an upload on a page that we have through the website, and Rochelle is just going to pop that link in to the comments there for us. So that's in detail, and it is quite a bit of detail. That's all there. All the need to know is there from Helen, her paper on the Design and Building Practitioners Act. Definitely check that one out. I am now going back to these questions. Excellent. Wonderful. Let me just scroll here. All right, I am seeing a question from Pamela. I'm seeing your question about committees, but then I'm also seeing a question from Jan about a builder. So I'm going to jump into Jan's question first while we're still on that topic, and then I'll come back to your very good question, Pamela. Jan says we have a builder who has a document signed by the developer that the developer will take on all responsibilities and that the builder will not be liable. They are each suing each other. Part of 6 strata schemes in a community association and another development lot. Can the builder transfer his responsibility? I would have thought not.
No. The duty of care obligations and under the Home Building Act, you can't contract out of your statutory warranties, you can't contract out of the duty of care obligations. So any contract or agreement that supposedly obviates somebody's duty will be considered void, cannot be delegated, cannot be contracted out of. So it's very clear provisions in the Act. Yep.
Okay, so you are, your gut is right there, Jan, and I imagine that you may have some legal advice, legal representation going on there. If not, and that's something that your owners corporation is involved in and concerned about, definitely head off and get that legal advice. I am now going to just deal with some random comments that are coming through here. Rochelle, I'll just get your help with those. And I'm heading back to Pamela. Pamela has asked, hi, Amanda and Helen, I have a problem with a hostile committee. What can the owners corporation do? Well, can I say this, Pamela? That is almost 80% of what I deal with when I'm helping owners to navigate difficult situations. I actually have a webinar, it's probably more than 12 months ago that I delivered it, and it was promoted as what is the #1 thing that dramatically improves apartment living? And the answer to that question is a functioning strata committee. So having a good strata committee in place is absolutely #1 importance, I believe, in having a nice, peaceful home to live in where you can enjoy your community. So having a hostile committee is really, really difficult. Pamela, my suggestion to those who have a hostile committee is try and get a new committee elected. And that's your job really as an owner. If you want a change, then put your hand up, get some support from your fellow owners who are eligible to be on the committee, others who may not be owners who are eligible to be on the committee, have a chat with them, let them know what it is that you think is not right, that you want to change and how you think the building could be better managed under a different committee. And at the AGM, when a new committee is being elected, it's out with the old and in with the new. But there's a bit of work in that, and not everybody's prepared to put in that work and make that change. That's something that's got to be up to you. Of course, there are litigious avenues and all sorts of other avenues. Helen, if you're still working with owners these days, I'm not sure, you're probably still maybe more focused on the developers and the builders at this point in time, but how do you recommend owners deal with hostile committees?
No, definitely still working with owners, majority of cases. Yeah, just try and obviously the main point of call is your AGM to get a new committee elected, as you've said, and try and get a functioning committee in there. I've just been involved in a massive case that went for 9 months in NCAT to try and get rid of a very hostile committee, and finally got some success there. But yeah, there's no need to put up with a hostile committee, and if there's enough people in support, then you can do something about it.
Yep, that's it. So I hope there is some guidance there for you, Pamela. I am just going to scroll down. Michael is saying, sorry, I might have missed it, but if a building is under warranty and needs combustible cladding removed, what can they do with this act? Is it now a major defect that they should handle with it? Helen, if you want to weigh in on cladding, you're welcome to. If you don't, I understand.
No, that's okay. I'm going to make a few brief comments. Look, cladding is an area where the councils can come in at any time and issue an order if the cladding is not compliant. As to whether it's a major defect depends on the compliance with the BCA at the time of construction. It depends on the product. It depends on a lot of things. There has been a case which held a builder responsible even though it was compliant at the time, but it doesn't protect an owner's corporation if 20 years down the track a council issues an order for non-compliant cladding. The owner's corporation just have to wear it.
Okay. All right. Well, I hope that helps to give some guidance there, Michael. I did see another comment. Pamela was saying thanks, but we had our AGM recently and it's not working, that you can't get a new committee elected. I think Pamela was saying, for anyone who missed it, what do I do about a hostile committee, and can't deal with that at the AGM? Well, you might be in that category there that Helen mentioned. You might have to end up in litigation there, Pamela, if you're looking at potentially being a dysfunctional scheme. I released a podcast episode a couple of weeks ago now about what is it that makes a scheme dysfunctional and how do you successfully run an application for the compulsory appointment of a managing agent who then takes on the powers of the owner's corporation. So you may have caught that one, Pamela, you may not have. So consider whether your building, your owner's corporation may be falling into that category. All right, what's on for the weekend, Helen?
Not much, actually. It's been a busy couple of weeks, but I have a very large pile of reports here to read. But
I was going to say you're not working, are you?
Oh, well, maybe a little bit, but no.
There's always something to do.
Yeah.
All right. Well, we still have 10 minutes left of happy hour, guys. So you are, as I said, more than welcome to share your, pop in your questions into the comments. I'm just scrolling through and we've just had to weed through some unusual comments there, which is just sidetracked me a little bit. Excellent. I'm just scrolling through there. All right, so I do want to remind everybody, have a scroll back up to the top of these comments and you will see the links there to a few things. You will see the links to the fair trading summary of what's happening now with uncollected goods, no longer having section 125 in our legislation in New South Wales, and have a look there at that page on Fair Trading's website about what the changes are with that, something that took us by surprise a couple of weeks ago, that part of our legislation was repealed. Also a webinar on bylaws that I'm running for Cumberland Council at midday on the 6th of August. You will see a link there. And very importantly, a survey on sustainability infrastructure in apartments that you are welcome to complete before the 9th of August for our New South Wales government, together with our University of Technology and Green Strata. So there is a link there also to be completing that one. Okay, we have, Pamela is saying much appreciated. Thank you very much. You are more than welcome. And I'm seeing a comment here from Robert, which is a long one. Now, Robert, you posted earlier about what the difficulties that were happening in your building. And yes, okay. I think that's just an update there from Robert, who's saying that perhaps there is some delay going on. Delay is something definitely to be conscious of, isn't it, Helen, when we're working with strict timeframes. What happens in your experience where the builder has come back, they're fixing things, maybe not, they seem to be dragging it out, saying, yes, we're going to do it. You're entering into, there are contractors running around the building, but there are still this long list of problems that isn't getting any shorter. What do you say to buildings that are in that situation?
For those buildings, definitely don't let your warranty periods pass you by. Some builders are very good at dragging it out until 2 seconds past midnight on the last day, and then you'll never see them again. So if the builder's on site doing works, that's great. You can get an agreement, get some advice, get an agreement drawn up, impose some conditions, timeframes, what work is actually going to be done. So at least you have some comeback on the builder to protect the owner's corporation. If they're on site, you hopefully won't have to commence proceedings as such, but you should be able to get, if the builder's willing to and wants to fix things and stick by their word, then they will agree to enter into some form of deed or settlement agreement that makes them come back and fix it.
Yeah, and what about settlement agreements that don't necessarily involve coming back and fixing it, but involve a payment to the owner's corporation, and the owner's corporation takes that money and fixes, and the builder walks away? Is that something that, you know, works for some, may not work for others? What's your experience with those kind of deals?
Yeah, look, they definitely work. If a builder's not able to come back, or there's some history involved where, you know, the owners don't want the builder back, and you can come up with a figure of how much things are going to cost to fix, and the builder's willing to pay that if it's under an agreement, then the owners do have the choice of who they get to do the work, and they will get a contract and further warranties, further rectification work. So that is sometimes the best option available. Many builders obviously want to come back and fix things because otherwise it's going to cost them too much money, because they quite often get their subbies back to do the work, the people that have caused the problems in the first place. So yeah, but money settlement agreements are common, and it's just worthwhile to be very clear on how much things are going to cost to get fixed. There's if you don't do the research and find out, get quotes and find out how much things are going to cost, and cost to do them properly, make sure you've got decent scopes of works, then you could find yourself accepting a sum of money and it not being enough to fix things.
Very, very good advice. And I have been approached by owners before who've been some years down the track, and they've said, oh, my owner's corporation did this deal with the builder. They got paid a bunch of money to fix the problem. Builder walked away, was released, and owner's corporation never fixed the problem.
Yes, that can happen as well. That can happen as well. And, you know, you can get some items that are, you know, not urgent that the owner's corporation might deprioritize, but the money should be used. Obviously, you have your repair and maintenance obligations, so it should be used to fix the problems.
Yep. Absolutely. All right. Now we are getting some more questions here about strata committees, Helen. This is the topic of the day. We're going to have to do another live all about strata committees. Glenn is asking, hi, Amanda and Helen, what happens if the strata committee keeps changing decisions that were made by the owner's corporation? Is it a problem if it's in the best interest of the owners? Very interesting. And Gary says, good question, Glenn. Do you want to start? I'm happy to.
Look, obviously, unless there's restrictions on the strata committee, they can make decisions on behalf of the owners corporation. So it just depends what those decisions are and whether there's any restrictions placed on the committee. And yeah, I don't know, what are your views, Amanda? I think if it's a pretty big decision, then it should go to a general meeting.
Yeah, well, I can see Gary's picking up on what you're saying there, Helen, because he said just earlier, strata committees have executive read Trump powers. So if you're talking about Trump there, or you're talking about the strata committee's powers, Trump the owners corporations. Something to be clear about, and I'm not sure if this is where your question was going, Glenn, if the owners corporation has made a contrary decision. So if the owners corporation, if say it's exactly the same issue, whether or not to fix something, the owners corporation has resolved to, in a general meeting, to repair the front fence or whatever it is, and to do it by a certain date. In my view, the strata committee, while they do have powers to make decisions of the owners corporation, as Helen says, unless otherwise restricted, you know, they can't make bylaws, they can't raise levies, they can't engage a strata manager. Our legislation says that those things are only matters to be decided by the owners corporation in general meeting. In my view, they also can't make a directly conflicting decision that has already been made by the owners corporation in general meeting, because they are then doing something in direct contradiction to what the owners have decided. So I don't know if that's what's happening in your example there, Glenn, if you want to pop an example in there. And Gary's saying, yes, it was the Donald Trump that he was referring to. Beware also, if this is an ongoing problem, owners do have a right to object to motions that are on a committee agenda. So as long as your strata committee, and I appreciate that this is a problem in itself, is issuing notices of meetings, and you've got that 3 days notice that you need in New South Wales before a strata committee meeting happens. I always get this confused, whether it's 1/4 or 1/3. I get it confused with a qualifier.
1/3.
One third of owners, because a qualified request is 1/4. One third of owners can write opposing a resolution of the strata committee before it happens. So you see the motion that it be resolved to do A, B, and C. Strata committee is going to have a meeting on Thursday. If 1/3 of owners writes in to the secretary and says, we oppose this motion being resolved, then it cannot be resolved. So that's in our New South Wales legislation. So if this is an ongoing issue for your owners corporation, you can be on the front foot there if you've got 1/3 or more of owners supporting your position. I'm getting some clarification here from Glenn. These are decisions that have already been made and they've done something else, such as picking an insurance broker or selecting the AGM, selecting the auditor at the AGM. Yeah, so I would say if you've got a motion at an AGM appointing an auditor, and that's a statutory motion. That is a motion that has to go before an annual general meeting pursuant to our legislation. The owners corporation can or doesn't have to appoint an auditor, but if they've decided to appoint an auditor, in my view, the strata committee, it's like an instruction to the strata committee. They're bound to follow that instruction, and they should be appointing the auditor. Otherwise, they're not acting with authority. They're acting in not appointing the auditor. They're acting without authority.
Yeah, I'd agree with you.
Sorry, I get a bit verbose sometimes. I have to force myself to take a breath. Strata, it's exciting. Do you feel the same way, Helen?
Yeah, it definitely keeps us entertained. It's like a different exam question every day.
I know, yes. It keeps us on our toes, that's for sure. And that's why I love doing this. I always say I learn so much, not just from my guest experts like you, Helen, but also from those of you who are tuning in. And I as you know, as you can tell, I'm not afraid to put it out there and say, hey, ask us whatever you like. We'll see where we get to. We all learn from that. And many a time I have found new sections of the legislation, new cases, new ways to think about things from a question that I've been asked. So keep them coming, happy to. I have forgotten in our rush of trying to get the tech working at 4 o'clock to close my door, and now my dog's running in and out. Little Louis here eating things that he shouldn't be eating. So we're going to just resolve that one very shortly. But it has been lovely to have you here with me for happy hour today, Helen. Please do, if you want to, if you don't mind being inundated, let our listeners know and our viewers know the best way to contact you if they want some more one-to-one guidance, and Rochelle will pop that into the comments for us.
Yeah, no, just contact me at SWAB and give me a call or shoot me an email.
Yep. Google Helen Cowell at SWAB.
Yes.
That's where to find her.
Fine.
Excellent. Well, you have a lovely weekend. Everybody who is here with us, thank you so much for joining us. If you have liked what you've heard today, it's something that you want to share, please do. The more people we can reach and help, the better. Give us a thumbs up. Send us all those good Facebook vibes. My puppy Louis is just digging into a cardboard box here next to me. I'm going to go sort that out. I think he wants some dinner. I think it's my job to give him some dinner right now. Great to have you, everybody. We will catch you next time. Thanks.
Thanks, Amanda. Bye.